A CCH is a formal hearing held by the Division of Workers' Compensation. This means that sworn testimony will be taken and a court record will be made. Instead of a benefit review officer, the hearing will be presided over by a hearing officer. This person is also an employee of the Division of Workers' Compensation. However, their role is much different from a benefit review officer's role. The hearing officer is the sole judge of your case. This means that he or she is the judge and jury, and they have the power to issue orders with or without your agreement. For this reason, it's imperative that you do your homework, work closely with your ombudsman, and come to the CCH prepared to prove your case.
The first step I took to resolve my claim was the benefit review conference. Unfortunately, I wasn't able to reach an agreement with the insurance carrier, so I've taken the next step and am now preparing for my contested case hearing. In my case, I injured my low back on November 1st, and I thought I would feel better by the next morning, so I didn't report it that day. However, when I woke up, my back felt worse, so I told the administrative assistant at work about my injury, and she told me that she would file the workers' compensation paperwork, and that the insurance carrier would be in touch with me. I never heard from the insurance carrier, and I kept working, even though my back still hurt. Finally, my back got so bad that on December 4th, I had to go to the emergency room. I told the doctor in the emergency room that I had hurt my back at work about a month before. The doctor's office must have contacted the insurance company because about a week later, I received a letter from Big Tech's insurance company stating that they were denying my claim because I was not injured at work and because I failed to timely report my injury.
It's very important for you as an injured employee to maintain the documents associated with your claim. The most common types of documents will be medical reports, diagnostic test results, and things like pay stubs or other employment records. There are also critical deadlines for you to pay attention to. For example, after the BRC, you have 15 days to exchange any documents you plan to use as evidence in your CCH. You should also plan to attend your CCH within 60 days of your last BRC. For the purposes of this video, the testimony and procedures shown in this hearing will be a shortened version of what occurs in an actual contested case hearing. In reality, you can expect a contested case hearing to usually last between 1 and 2 hours.
The matter of Danny Montoya versus Big Tech's Insurance Company, docket number AU1245 is now called to order. This proceeding is being held pursuant to the Texas Labor Code and Division's rules. My name is Jaime Cruz, and I'm the hearing officer in this matter. It is my job to act as the sole judge of this case. Mr. Montoya, I am not here to represent the Division of Workers' Compensation. I am here as an impartial party to judge the facts in this case. And because this is a legal proceeding with legal consequences, you have the right to be represented by an attorney. You also have the right to request an ombudsman to assist you at no charge. Do you understand these rights as I have explained them to you?
Yes, Your Honor.
Do you wish to have your ombudsman assisting you in today's hearing?
Yes, Your Honor.
Very well. Have you had a chance to meet with your ombudsman for at least 15 minutes prior to this hearing?
Yes, Your Honor.
Very good. Also present today is Maria Ames, representing Big Tech's Insurance Company. We are here today to resolve the matter of Danny Montoya versus Big Tech's Insurance Company. I have marked the Benefit Review Conference Report as Hearing Officer Exhibit 1 and the Carrier Information Form as Hearing Officer Exhibit 2. Are there any objections to admitting these exhibits into evidence?
No, Your Honor.
No, Your Honor.
From the Benefit Review Conference Report, I see that the issue is whether or not the carrier is relieved from liability under Section 409.002 of the Texas Labor Code because the claimant failed to notify his employer within 30 days of his injury. Is this correct?
Yes, Your Honor.
Yes, Your Honor.
Both parties will be given a chance to present their side of the case, call witnesses, and cross-examine the witnesses. You will also be given the opportunity to respond to the other side's argument. The party with the burden of proof in this case is the claimant, and you may begin with your opening statement.
Thank you, Your Honor. We are here today to resolve the issue of whether or not Mr. Montoya notified his employer of his injury in a timely manner. We will argue, and the evidence will show, that Mr. Montoya notified his employer of his injury on November 2nd, which was the morning after his injury. It is our contention that the carrier did not receive notice until over a month later because of an oversight on the part of Mr. Montoya's employer. For this reason, the insurance carrier cannot be relieved of liability under the law. Thank you.
Very well. Ms. Ames, you may open.
Thank you, Your Honor. We received Mr. Montoya's notice of injury on December 6th, which was after the 30-day deadline. Prior to receiving that report, we had no other knowledge that Mr. Montoya was injured at work. In addition, we do not show that Mr. Montoya has shown good cause for failing to timely notify his employer. For these reasons, we will argue that we are relieved from liability under the law. Thank you.
Very well. Now that both parties have given their opening statements, Ms. Carter, would you like to call any witnesses?
Yes, I would like to call Mr. Montoya to testify.
Very well. Mr. Montoya, would you please take the witness stand? Would you please state your full name for the record?
Danny Montoya.
Mr. Montoya, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Ms. Carter, you may proceed with your direct examination of the witness.
Thank you. Mr. Montoya, would you tell me about your injury, beginning with when you were injured?
On November 1st, I injured my low back after retrieving a box of machine parts from a shelf. I fell backwards after feeling something pull on my low back. I dropped the parts on the ground and had to lie down from the pain.
Did anyone witness the accident?
No, the other employees who were on the factory floor had hearing protection on, so they didn't hear the crash where it was.
And did you continue to work that day?
Yes, at first the pain was pretty bad, but I did a little stretching and my back seemed to loosen up, so I just went back to work.
And what happened the next morning?
When I woke up, my back hurt pretty bad, so when I got to work, I told our administrative assistant, Ms. Hiller, about the injury so that they could file a workers' compensation claim in case I missed work or had to see the doctor.
Why did you tell Ms. Hiller?
Because the other employees and I had been told to report any on-the-job injuries to Ms. Hiller because she was in charge of sending the workers' comp paperwork to the insurance company.
And did you end up going to the doctor?
Not at first. Basically, I thought I could just deal with the pain and let my back heal on its own. But after a couple of weeks, the pain only got worse, so I had to go to the emergency room. And after that, I received a letter from Big Tech's insurance company denying my claim because I had not notified my employer that I was injured at work within 30 days.
Okay, no further questions at this time, Your Honor.
Ms. Ames, you may begin with your cross-examination.
Thank you, Your Honor. Mr. Montoya, you claim that you were injured on November 1st, correct?
Yes.
And you claim that you told your company's administrative assistants about the injury the next day?
Yes.
Why didn't you see a doctor as soon as the injury happened?
Basically, I could treat the pain with aspirin, and as long as I didn't have to lift anything heavy or stay on my feet for a long time, it wasn't too bad.
How many of your co-workers were working on the factory floor at the time of your accident?
Maybe 3 or 4.
And none of them witnessed the accident?
No, they all had hearing protection on.
Do you have anything that might show us that you did in fact tell the employer that you were injured on November 1st?
No, they didn't give me anything to sign when I told them.
Carrier passes the witness.
Ms. Carter, do you have any follow-on questions?
Not at this time.
Ms. Ames, do you have anything further?
No, Your Honor.
Very well. Mr. Montoya, you may step down.
Thank you.
Would you like to call any witnesses?
Yes, Your Honor. We would like to call Ms. Hiller to the stand.
Hello, Ms. Hiller. Would you please say your full name for the record?
Celeste Hiller.
Ms. Hiller, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Very well. Ms. Ames, you may proceed.
Ms. Hiller, at your company, are the employees told who to report their workplace injuries to?
Yes.
And who are they supposed to report them to?
To me.
So it's part of your job to report workplace injuries and to file the appropriate workers' compensation paperwork?
Yes.
Did Mr. Montoya report a workplace injury to you on November 2nd?
No, he did not.
Did Mr. Montoya ever report this injury to you?
Yes, but not until over a month later.
And what did you do when he reported the injury to you?
I immediately filed the required paperwork with the workers' compensation insurance carrier.
No further questions. Carrier passes the witness.
Thank you. Ms. Hiller, is there anybody else at your work who is supposed to file workers' compensation claims?
No.
So you're the only person who does that?
Yes.
And just for the sake of argument, would you get into trouble if you didn't report someone's injury on time?
Well, I guess so, but I always file things on time.
I have no further questions at this time.
Ms. Ames, do you have any additional questions for the witness?
No, Your Honor.
Ms. Carter?
No, Your Honor.
Very well. Ms. Hiller, you may step down. Ms. Carter, do you wish to call any other witnesses?
No, Your Honor. Claimant rests his case at this time.
Ms. Ames, do you wish to call any additional witnesses?
No, Your Honor. Carrier also rests its case.
At this time, I ask that both parties give their closing statements. I will give each side 2 minutes to present their closing arguments.
Thank you, Your Honor. Mr. Montoya has testified under oath today that he notified his employer of his injury the day after it occurred. It is his contention that it was the fault of his employer for failing to report his injury to the insurance carrier until over a month later. Unfortunately, this has resulted in his claim being denied by the insurance carrier. Mr. Montoya was well aware of the process for reporting claims to his employer, and his testimony establishes that he met the timely reporting requirement. We ask that you give his testimony the weight it deserves. Claimant prays for a favorable decision. Thank you.
Ms. Ames, you may now give your closing statement.
Thank you as well, Your Honor. Despite Mr. Montoya's testimony, the evidence clearly shows that he failed to report his injury within the required time frame. In addition, there is no evidence to support the position that Ms. Heller failed to fulfill her job duties concerning reporting workplace injuries. For these reasons, Big Tech's insurance company seeks relief from liability, and we pray for a favorable decision in this case.
Ms. Carter, do you have anything you wish to add?
No, Your Honor.
Very well. At this time, the hearing is concluded. Based on the evidence presented in this hearing, I will write a decision and send a date-stamped copy of it to both parties. Either party may appeal the decision. If you wish to appeal this decision, you must file your appeal with the Division of Workers' Compensation in Austin, Texas, no later than 15 days after the date you receive the decision. The record is now closed in the matter of Danny Montoya versus Big Tech's Insurance Company.
The outcome of your case depends on many factors, some of which you have control over and some of which are outside of your control. There is no surefire way of winning. The best things you can do to give your case the best chance of winning are to be prepared and timely in everything you do, and it's always in your best interest to have someone assist you who is knowledgeable about the Texas workers' compensation system. For the purposes of this video, we will now explain what to do if you don't succeed at a contested case hearing. We have done this to demonstrate the next step in the dispute resolution process.
I found out yesterday that I was unsuccessful in proving my case at the contested case hearing. According to information I've been given, I have 15 days to file an appeal to the Division of Workers' Compensation. My ombudsman can assist me with this process. However, there won't be another trial to attend. This is also the last step in the dispute resolution process for which an ombudsman can assist me.
While most claims will be settled at the BRC, the CCH, or at the appeals panel, there are times when a claim is appealed to a higher level. After the appeals panel, claims leave the dispute resolution system and are heard in the district court like any other legal matter. But most likely your claim will be resolved at either the BRC or the CCH. On behalf of the Office of Injured Employee Counsel, we wish you a speedy recovery and look forward to hearing from you. Thanks for watching.